Good morning, FSACCI members and friends, and welcome to another edition of our COVID-19 webinar series. Today, we're going to be chatting about data privacy in the time of COVID-19, as well as in light of the POPI Act. I think this is a great topic that Adams is going to, their expert is going to talk us through today. And I think with everything going on, we've been a bit preoccupied, so it'll be good to get a recap on where we stand with POPI, as also emerging privacy topics that are going to be emerging in light of COVID-19, particularly as we're all adopting new technologies as well as working from the home office. So it's my absolute pleasure today to introduce to you the Adams expert, and that is Dr. Dani Strachan, who is a partner at Adams & Adams, and he's going to be walking us through POPI Act as well as emerging data privacy topics in light of COVID-19 today. Before I hand over to him, just the general format. As always, we're going to hear from the doctor. He's going to walk us through that. Then we're going to be followed by a Q&A session. Today's Q&A session is going to be facilitated by the Q&A type box at the bottom. So if you have any questions, feel free to type it in the Q&A box, which is located at the bottom of your screen. Feel free to ask us your questions and lean on the expertise of Dr. Strachan today. So those who are just joining us, welcome to Adrian. We have Andrew, Emma, Jay, welcome, Melanie from FSACCI. Thanks for joining us. Vicky, Paul. So while we let the others get started, just a reminder that we're speaking about data privacy in times of COVID-19 and in light of the POPI Act. And on that note, I'm going to hand over to you, Dr. Strachan.
Good morning, everybody. It's nice to meet you virtually. Changing times. I normally like presenting in person where we can see everyone and see reactions and chat and still shake hands. Unfortunately, times have changed, and I suppose we'll have to get used to that. Hopefully, the change will revert back to normal again sooner than later. Okay, as Amy has said, we're going to chat about POPI this morning, but I actually want to sort of cast the net a little bit wider and to talk about privacy and data protection in general in the times of COVID-19, these really extraordinary pandemic times that we face ourselves today. So yes, I'll be chatting about POPI, but I also want to talk about some other general data protection and good privacy governance principles. When it comes to POPI, just the latest status. The information regulator announced earlier this year that she wrote to the president to request him to enact POPI on the 1st of April. In other words, to let POPI have legal effect from the 1st of April. The 1st of April has come and has gone, and POPI is not in effect actually. So we don't actually know when POPI is going to be law. There are some sections in the Act that are in effect. Those sections basically give power to the regulator to fulfill certain functions, to draft regulations, but the meat is not enforced yet. The substantial sections that tell us how to process personal information, the sanctions, all the other relevant provisions are not enforced yet. So as things stand, and there is a lot of confusion about this out there because a lot of people think that POPI is actually in law. A lot of people are writing to the regulator to report breaches of the law, but the reality is that POPI is not yet in force. What the regulator is doing at the moment, though, is to issue sort of guidance and advice relating to data protection and privacy, but that is not binding. So they cannot actually take someone to court on account of a breach of some section in the Protection of Personal Information Act. So even though that is the position, the regulator is from time to time issuing guidance. Very recently, I think it was actually during the course of the last week, the regulator issued guidance specifically related to the COVID-19 situation. The guidance refers back to the disaster management regulations. And I'll touch on that a little bit later during the course of the webinar, because it's quite an interesting and quite a relevant way of applying POPI's principles to practice. So what the regulator has done is they've taken POPI's principles, and there are a number of information protection conditions or principles in POPI, and those have now been applied to a real life situation. In other words, the coronavirus pandemic that we're facing, including compliance with the disaster management regulations that were issued to try and manage and curb the spread of the virus. So that is my introduction. I just want to set the context when it comes to data protection, privacy, all these concepts that we talk about, just to recap and make sure that we understand what we're talking about. So as I've said, our data protection law, in other words, POPI, the Protection of Personal Information Act, is not yet in force. When it comes into force, it will regulate on a very comprehensive basis the processing and protection of personal information in South Africa. This kind of legislation is found across the world. It is the trend to protect people's privacy. So unfortunately, South Africa is a little bit behind the curve. Even a number of other countries on the African continent have enacted data protection legislation. So we really need to catch up in that regard. But let's talk about the concepts. So if we talk about privacy and dignity, those concepts are found in our law. It's found in what we call the common law. It is referenced in our constitution. But what are these concepts? So if I talk about data protection and privacy, what are these? In very simple terms, privacy, or privacy as the Americans might pronounce it, basically is someone's innate human right not to have their personal affairs be broadcast to the public. So basically, it gives you the right to say that there are certain facts, there's information, there are details, there's data that belongs to me and should not be made available to the public. And this is very closely associated to the concept of dignity, which is recognized by our constitution as well. So these two concepts are actually tightly intertwined, because your privacy also protects your dignity. If someone invades your privacy, your dignity is also infringed. So this is a very, very basic personal human right. And that is why the Constitution recognizes people's rights to privacy. When we talk about data protection, it is very closely linked to this concept of privacy. So data protection entails the concept that people have data, and the data needs to be kept from the public domain, to be kept from the public realm. And this whole need was actually recognized way back in the 1970s already. There was quite a big conference in Australia where a very prominent judge spoke, and he said that humanity is actually facing a crisis, and at that stage he said that he foresaw that the rapid changes in technology will really affect people on a very basic human rights level. And that's when this whole movement started of protecting people's data. And if you think about the 1970s, the internet wasn't really around yet. Email was definitely not around in the 1970s. Facebook, WhatsApp, Instagram wasn't there. But even at that stage, they were worried about what technology might do, how it might change people's privacy. And that led to the adoption of what is known as the OECD principles. And those principles are incorporated or followed in most countries' data protection legislation. So there are certain key fundamentals when it comes to privacy. And those fundamental privacy protection principles or conditions or requirements are also reflected in South Africa's Protection of Personal Information Act, the POPI Act. And we'll look at those a little bit later. But the reason why data protection has become so important is because there's this increased vulnerability. We're vulnerable because our privacy is at risk. And it's at risk because of the information age that we live in. And if you think about it, information technology has proliferated. There's just so much happening out there. When you register an email account on the internet, you have to tick certain boxes. And if you read the privacy policy somewhere in the fine print, it will say, by using this service, you agree that we can investigate websites that you visit. We can maybe trawl through your emails to see what you're interested in so that we can target advertising and marketing at you. And that's just one example of how our privacy is at risk, but it is a balancing situation. So often voluntarily, we allow people to a certain extent to invade, if I can call it that, our privacy, because we need a service. So we need a social network platform, we need an email service, and because we want that service, because we can't pay for that service to be created, or we don't want to pay for a subscription or for software licenses, we use a free web-based service, or we download an app. And basically what we do is we pay for that service, we pay for the social network or for the email access by giving up some of our privacy. So it's an interesting transaction. There's a lot to be said about that. You can have long philosophical debates about that, but that is why we need this kind of legislation. If you think of long ago, so let's say not even that long ago, if we talk about the 1900s, before the internet, it was actually not that easy to invade someone's privacy. You'd have to try and tap their phones. I suppose if you had one of those old telephone exchanges, well, maybe you could just pick up the receiver and listen in on someone's conversation. But before that, you'd have to basically climb over someone's wall to invade their privacy. You'd have to open their mail, or you'd have to tap their phones. But these days, we use the internet to exchange information in all sorts of ways. And there's so much information out there. We store so much information on so many platforms and on devices and on disks. I think the fact that it's so easy to multiply information has increased this risk. So if you just think about how easy it is to copy and paste something, or to save something on the cloud, on your phone, on your laptop, and you just increase your own vulnerability and exposure. So that's why we have these laws, why we need these laws. But it's also because of this risk to individuals that organizations have to toe the line and to follow good corporate governance principles. So even though our law, POPI, is not yet in force, there are a number of reasons why it's important for organizations to recognize and to protect people's privacy, to protect their data. The first and probably one of the most important reasons to do so is for a company to protect its reputation. And we've seen so many information breach situations where prominent brands featured in the press because they've suffered some form of hacking incident, some form of virus that locked down their information, or information that was published on what is known as the dark web, or on the general internet that we all normally used to. That and those situations can really tarnish a company's reputation, its brand value, and consumer trust. So if you share your data with a company and you suddenly see your data publicly available on an internet because someone managed to hack into their systems, or an employee leaked the information, you'll think twice before you use them again. So even though there might not be a law that says that we have to comply with certain principles, it is important for a company to protect its reputation, and it can do so by making sure that it respects people, and specifically when it comes to their privacy and to the protection of their data. And also because this has become the international gold standard to protect people's information. We are in a position at the moment where a lot of companies might perhaps not make use of your services because they would be worried that their local laws will prevent you from using your services because your services do not comply with certain basic privacy principles. So to make sure that you can keep on doing business with existing clients, but also in order to bring in new clients and customers, if you can state that you comply with international privacy standards, that is a marketing benefit. It's a selling point that you can use. And we often see this with bigger companies in South Africa, those that have contracts with international clients. Those clients, before you can even start doing work for them, might do an audit on your privacy practices, on the state of your information technology systems, and they might not appoint you to provide services to them unless they are happy that you're complying with those requirements. And then, of course, if something does go wrong, if in your organization privacy is not handled properly and there is a breach and that can lead to damages to someone, there is a risk that you'll be held liable in a court, even if we don't have a law as it stands at the moment. So POPI will one day allow data subjects to sue companies if there was an information breach and they suffered damages. But even if at the moment, under our common law, so our common law is the law that has been built up over the course of centuries. It sort of came over from the Romans and from the Dutch and from England, and that has sort of been absorbed into our own legal system, coupled with all sorts of legislation. But under our law at the moment, if you can prove that someone did something and that what they did caused harm to you, you can sue them for that. So even though there's no law that says you have to comply with X, Y, Z when it comes to people's personal information, there is this risk that you could do something wrong, that the information is leaked, and that you are the direct cause of damage. So very simple example, if a company, let's say it's a website that is secure functions. So the password is your access to the website. If that password is leaked out because of bad internal controls, and someone can get hold of that password and process some kind of transaction, so money is lost, or someone suffers some other form of damage, if they can prove that you didn't do things properly, or that you allowed, for example, a password to be published on the internet, didn't take steps to stop the harm, so you didn't send reminders to people or notifications saying your password has been leaked, change your password immediately. And if there's, let's say, a credit card linked to that account, you can buy stuff automatically if you can get into that site. A consumer can show that it has suffered harm, and that can lead to a real risk. So it's important to make sure that you avoid that kind of liability. And as I've said, there are international standards that deal with these things. So if you want to do business on the international stage, it's important to make sure that you adhere to these requirements. At the moment, as I've said, our constitution does recognize that every person has the right to privacy, even juristic persons, in other words, companies, closed corporations and the like. They, to a certain extent, also have privacy. And the RICA Act, that's now the Regulation of Interception of Communications Act, if I can give it a short name, that also regulates privacy because it allows you to intercept and to monitor communications in certain situations. This act is actually quite a lot in the news at the moment because the High Court has declared the act unconstitutional, on the basis that the checks and balances aren't in place. So basically it allows government to overreach when they want to monitor people's communications, if they want to intercept those communications. So at the moment it is actually with the Constitutional Court. The matter has been argued. We're now waiting for the Constitutional Court's judgment on whether or not RICA is unconstitutional. If it is found unconstitutional, then Parliament will have to cure the problems in the Act in order to make it constitutional. So the Constitutional Court will probably afford them a specific time period to deal with that. The disaster management regulations that we've all probably heard about a lot in the last few weeks also contain some provisions that relate to privacy, specifically relating to the tracking of people's movements. And we'll touch on that a little bit later on. I've talked about POPI and our common law already. So these are the laws that are relevant one way or the other when it comes to data protection in South Africa. So just to touch on these concepts, because I think it's important within POPI's context to understand what we're talking about. So personal information is any kind of unique information that relates to an individual. So in other words, someone's address, their telephone number, their fingerprint, any kind of information that relates to a person is personal information. So information must relate to a person in order to be personal information. So if it's just general information, so if you just know that someone likes chocolate, that is not personal information. But if you know that I like chocolate, then we're dealing with personal information because the information can be related back to me. It's important to understand that there's a difference between personal information and confidential information. So confidential information is normally information that a business wants to keep secret. In other words, it does not want the public to have access to that information because it might be sensitive financial information, or it might be trade secrets that they use, in other words, to the recipe or a formula for a paint or for a soft drink, for example. It doesn't mean that if information is personal information, that it is automatically confidential information. So some information you might actually be able to find in the telephone book, if you still have access to a telephone book, but that information might not necessarily be confidential because it's in the telephone book. It is, however, personal information because it's someone's phone number or could be their address. So it's important to distinguish between these concepts. However, when POPI is enforced, if you have personal information, you have to treat that information as confidential. Whether or not it is in the public domain does not matter. The fact that it is now within your organization, that means that you have to therefore treat it as confidential. In other words, you can't then, unless POPI allows you to do that, make that information public. And just to talk about certain other concepts that feature in POPI, because I'll talk about them a little bit later on. There are certain role players that feature in POPI. So if this was a drama, we are talking about the actors here. So the data subject is probably the most important when it comes to POPI. The data subject is the person to whom the personal information relates. So if you know that I like chocolate, I am the data subject because that information that you know relates back to me. The responsible party is the person that processes the personal information. So if a company does a market survey to find out whether or not people like chocolate and they're taking down those results, that company is the responsible party. So it is responsible for making sure that it processes personal information in compliance with the law. An operator, which is a strange term that they chose, but an operator is basically a third party that processes personal information for someone else. So if you are a chocolate manufacturer and you want to know whether people like chocolate and you appoint a marketing survey company, that marketing survey company is your operator because they are processing other people's personal information for you. If you as a company appoint an IT consultant or your HR services are outsourced to someone else, those external bodies are regarded as operators. The information regulator is the government watchdog that looks after privacy matters and that will enforce POPI when it has become law. And then all organizations will be required to appoint information officers. So those will be senior people inside an organization, normally the most senior person, although they can delegate this duty. And that person's job is to make sure basically that the company complies with the law. So quickly, I can do a very long presentation on POPI, but in a nutshell, I want to look at some of POPI's principles. And I've taken my lead here from the guidance note that the information regulator has published, because what they've done is they've taken the POPI principles and placed them in the context of COVID-19. So I'm going to take you through these principles and then talk about how they are relevant when it comes to the current situation that we are facing. And that even though these principles are contained in POPI, as I've said, POPI is not yet in law, these are still good principles to adhere to. As I said earlier, these are international gold standard kind of principles. So it is important to at least know what these principles are, to see where and how you can apply them in your organization. And you could almost use this as a test, as a dry run for trying to comply with POPI, because this will give you a good opportunity to identify certain weaknesses, to see where the loopholes are, to see where there is work that you can still do to try and make sure that you will be ready for POPI when it does become law. So the first principle in POPI speaks for itself. It requires you to be accountable. So a responsible party is required to make sure that it complies with the laws relating to privacy and that it can show compliance. So you're actually required to document your processing to make sure that if the regulator, for example, wants to do an audit, or if there's a court case or an investigation, that you can prove that you hold yourself accountable to the law and what you've done to do so. Then the lawfulness requirement is very similar to that. Basically, when you process personal information, you have to make sure that it is legal. So let's say POPI is not enforced yet. It doesn't mean that you can then just do what you want with personal information, because there are still other laws that apply. As I've said, our Constitution recognizes the right to privacy, and there's been a number of court cases that have dealt with that right in a number of contexts. Many of those cases dealt with health status, quite interestingly. So in the current context that we are finding ourselves, that might pop up again. So when you process personal information, you have to make sure that what you're doing complies with the law. And then an interesting point, I think, and this is something that a lot of people will be grappling with when POPI comes into law, but even in the current circumstances, we need to figure out what we do with this. And this relates to when you may process personal information. So the processing of personal information deals with anything and everything from collecting information, consulting personal information, merging information, up to destroying the personal information. So all of that is processing, but there are only certain instances in which you are actually allowed, or you will be allowed under POPI, to process personal information. Now, the easiest one is if you have someone's consent. So if they sign a form and say, yes, you can use this information for this purpose, then you are allowed to do so. POPI says that consent must be clear, and it must be expressed, and it must be informed. So in other words, someone can't just require you to sign a very vague, short document that doesn't really say what they are going to do with your personal information, what information they are going to collect. They have to be clear so that when the person gives consent, that they know what they are agreeing to. So the first one is if you provide consent. There are also other situations that will allow you to process personal information without consent. So there is a misconception out there that you will always need consent to process personal information when POPI has become law. That is not actually true. So if you don't have consent, you could also be allowed to process personal information, for example, if there's a legal requirement, and that speaks for itself. So for example, our FSACCI law, if you're a bank or an estate agent or an attorney, and you have to verify someone's identity in accordance with FSACCI's requirements, so you are required to ask for a copy of their identity document for proof of residence. If you are processing that personal information, you don't need consent because there is a legal requirement that tells you to do so. Under the current situation, under the COVID situation that we are facing, the disaster management regulations talk a lot about people that have to submit themselves to testing, to agree to testing, certain information that can be gathered by government. So at the moment, we have the disaster management regulations that impose certain duties when it comes to the gathering of personal information. You can also process someone's personal information if you have a duty towards them in terms of a contract. So if a courier company needs to deliver something to someone, they don't need to get consent to obtain their address. They have to have the address in order to deliver the parcel to the person. So they don't need to get consent. They can just use that personal information in order to fulfill a function under a contract. You can also process personal information if it's in the data subject's legitimate purposes. That's complicated concept that is not defined in the Act. But in other words, if you have a reasonable legal purpose for processing of the personal information, you can do so. So obviously, if you're trying to save someone's life and you're trying to get hold of their emergency contact, you can't be expected to try and get consent from someone who might be unconscious, but you can use that personal information for a legitimate purpose, which might be to save their life, for example. If you process personal information, you need to be able to justify it. You need to show why you're processing that personal information. So if we're talking about the current pandemic situation that we are in, you can process employees' personal information, perhaps in a different way in that you would normally process that information because situations have changed. Why you might not always have their cell phone number, for example, or their home landline number, but now you need to have that number because you have to get hold of them because they are not working in the office at the moment. Health information, one way or the other, you are going to process health information of your employees because they're going to tell you, for example, that they've tested positive for the coronavirus. And then you're going to have that information. And the question is, what are you going to do with that information? Data subjects, when POPI becomes law, will also be able to object to the processing of their personal information. However, if they do that, you'll have to tell them, well, there are certain repercussions. So the simple example that I can use is if you're a bank, if someone wants to obtain a loan from a bank and the person doesn't want to provide their bank statements or their pay slips, then they can obviously object to providing that information to the bank, but then the bank will probably tell them, well, I can't give you a loan if I can't see what your source of income is and what your income is. So linked to the above, information needs to be collected for a specific purpose. You can't just expect someone to give personal information to a company for any and all sorts of purposes. And then information needs to be retained. So sometimes a law requires you to retain information. In other instances, you are required to delete that information. So that is dealt with in POPI. What you have to be careful of is also where you've obtained information for a specific purpose, not to use that information then for another purpose that was not within the ambit of the initial purpose for which you obtained the personal information. So all of these principles will apply in the COVID scenario as well. There's a duty, for example, on you to make sure that the information that you obtain from someone is accurate and correct. So the best step here would be to try to get the personal information from the person to whom the information relates, instead of trying to get it from a third party. So if you can, it's always better to go to the source. There will also be a duty on you to make sure that you update information, that the information remains current. And then I think this is the most difficult aspect to deal with is information security. So it's a short section, relatively short section in POPI, but this places a duty on responsible parties to make sure that all the information that is processed by them is kept confidential, that it's kept free and safe from unauthorized access. And because of the way in which information is stored these days, this basically points to your IT processes in most instances, because information is stored on a server, it's stored in the cloud. The question here is are your measures appropriate? Are they in line with the benchmark to make sure that the information can remain free from being accessed by a hacker or a cyber criminal, for example? And that will be the case at the moment as well, and we'll talk about these things more practically in some of the latest slides. But if you think of the situation that we're in at the moment, where most people are working from home, the risks that the information could be leaked, those risks have really increased. So people are using their own devices. They might be using shared devices. They might be using devices that don't have proper antivirus software installed on them. They might be living in communal spaces where other people might have access to that device as well, where they're sharing Wi-Fi, where they're using free Wi-Fi that might not be secure. So unfortunately, when it comes to this requirement, the onus has become much more. It's become so much more difficult to comply with this requirement because you're not working with information in a contained environment anymore. So this is something that we'll have to look at specifically in the current scenario that we're in. And then just another issue that you need to be aware of, POPI distinguishes between what I could call ordinary personal information and special personal information. So special personal information is more sensitive. So this would be your fingerprint, your retina scan, and your DNA analysis, your health information, your political views, your labor union affiliation, all this kind of information. And in the current scenario, definitely your health information, your health status. This information needs to be treated with more care. In most instances, you can only process this kind of personal information if you have the person's consent. There are exceptions. So hospital doctors, those people can have access to personal information. Employers can have access to information in certain circumstances. But a general rule, when you deal with special personal information, you have to take more care. Also, an interesting and important point to remember is that children's personal information is always regarded as special personal information. So you'll only be able to process that personal information with the child's guardian or parent's consent in most instances. Of course, there are some exceptions again, for example, schools. But then there are requirements. You can't then just process the personal information for any and every reason. So let's talk about these principles in the context of the lockdown of the worldwide pandemic that has been caused by this coronavirus. And there are a number of important issues, I think, to focus on and make sure that you toe the line, that you respect people's personal information and their privacy rights. So the first one, practically, even though POPI is not in law, if you have employee health information, and we're not talking about specifically COVID-19 health information. So let's, for an example, let's use a situation where an employee informs you that they have tested positive for this virus. You obviously need to know that. So let's say the person works in essential services, so they are still at the office. You obviously need to take certain steps to make sure that you protect other employees. So you need to know this information. You are allowed to collect this information to make sure that you protect other employees and members of the public, if this was a supermarket, for example. But there are certain things that you can still not do. So you might perhaps, you'll find out that the person has tested positive. You can then tell the other employees that someone has tested positive. But that will not give you the opportunity to then go and disclose the identity of the person. So as far as possible, try and maintain confidentiality there. But obviously you need to try and work with that information in order to make sure that you try to take the necessary steps to avoid or to mitigate the spread of the virus. Just interestingly, in this context, we have other legislation that deals with the notification of certain diseases. So there's a list of diseases, and these are known as notifiable diseases. And for example, if a doctor knows that someone has tested positive for that disease, there's a duty on the doctor to report the situation to the health authorities. Now, that list, interestingly, also includes any respiratory disease caused by a novel pathogen. Now, and it actually mentions as an example MERS, which is a virus similar to the current coronavirus that caused a lot of deaths a couple of years ago. But that list is open-ended. So if you look at the current situation, the coronavirus that we are dealing with here is a does cause a respiratory disease, and it's a novel virus that has caused that. So those regulations under the notifiable diseases legislation actually apply here. Now, what people need to be aware of here is that the legislation doesn't only apply to healthcare workers, in other words, doctors or nurses or hospitals or clinics. It also says that if someone in the community becomes aware or as reasonable or has reason to suspect that someone has tested or is positive, then they have a duty to report this to the health authorities. So if you know that someone in your workplace has tested positive, there will be a duty on you to make sure that you report this to the authorities. So of course, if the person tested at a medical facility, in most instances, the authorities will already be alerted to this, but you might have a suspicion that this person has the coronavirus. And I don't want to make up the law here or make conclusive guidance for you, but if you know that someone lives amongst other people and all those people have tested positive, and this person shares a room perhaps with other people, and those people have tested positive, and this person has lived with them since the outbreak of the virus, for example, then you'll probably have a reason to suspect that that person might be positive as well, especially if they are displaying symptoms. So you have to manage these situations carefully. I wouldn't just sort of stumble in and try and deal with the situation on a whim. You'll need guidance. You'll have to make sure that you involve your lawyers or healthcare advisors so you can know what you should be doing, especially if there is a positive case in your workplace. And I'm obviously now not talking about healthcare law today, I'm talking about privacy, but these are situations where people's privacy will be infringed one way or the other. And of course, a lot of people might say, well, is this right? Is it reasonable? What about naming and shaming and the stigma attached? So there's a lot of discussions that we can have about that. But from a legal context, even though our Constitution in the Bill of Human Rights recognizes the right to privacy, the rights in our Constitution are not absolute. Well, some of them are absolute, but there are some rights that are, let's call them flexible. And those rights have to flex based on the exercise of other rights. So, for example, the right to life in most cases will be more important than another right. So your privacy, unfortunately, will not weigh stronger than someone's right to remain alive, for example. And that is what is being used in most contexts at the moment when it comes to the disaster management regulations. People's freedom of movement is being curbed and limited because we have this pandemic situation and we have to protect people's lives and make sure that they remain safe. In the workplace, well, most of us are not necessarily in our workplaces at the moment, but we have to make sure that we keep on providing guidance and training to people regarding privacy, especially at the moment. It's a good opportunity to give them basic training regarding privacy, but also to alert them to privacy risks. So it's a good idea to send out bite-sized reminders maybe once a week regarding using antivirus software, using devices, making sure that you have passcodes on your devices, what Wi-Fi is safe, when is it not safe to use Wi-Fi, VPNs, but also hard copy information. So it's a good opportunity now to, especially for many employees that might be working from home, but they might not be that busy. There's a lot of online training that you can even use, but you can also compile your own training to make sure that people upskill when it comes to privacy, but also to make sure that you mitigate against data breaches, for example, to make sure that you maintain and even if possible, strengthen your information security in your company. So of course, some employees, if they're working from home, need to get access to your servers. So it's important that they can still have that access so that they can still do their work. But you also need to think about this carefully. So do they need access to the whole server, or do they only need to access to a certain portion? Do they only need access to one file? Obviously, the bigger or the broader the access, the bigger the risk if there is some kind of information breach, that more information will be exposed. So try and manage this according to a, let's say, a need to know basis. If someone needs to have access to information, then it's fine. But if someone works in the marketing department, why should they now suddenly have access to the HR records, for example? So make sure that you look at this. And obviously, I'm not a security expert, but make sure that if you allow remote access, to try and make sure that, or you should make sure that the access is on a secure basis. And that is why most organizations use VPNs these days, and make sure that you use a reputable VPN service provider for this purpose. Another thing that you need to think about is where people store stuff. So if they work from home, they need to file documents somehow electronically. Where do they file that? Do they use a reputable service provider? Is it a service provider that has been hacked in the past? How secure is that storage? And then linked to that, of course, is the information backed up? So if someone works on their laptop and all the information is saved only on the laptop hard drive, laptops break and they get stolen. And what happens to the data then? Especially if the data is stolen, you might not know in whose hands the data might end up. So make sure that people back up their data, but then make sure that it's also backed up in a secure manner, using a reliable service. And then don't forget that information can also be contained on paper. So people might still be doing printing at home. Printing at home is actually a risk, because the more information you print out, the bigger risk that the information is going to land up in the wrong hands. So people print all sorts of things. They throw it in their waste paper basket, which then ends up in the black bin on the sidewalk when they come and collect the rubbish. And they don't think carefully about what is being thrown in the waste paper basket. They just print something quickly because they need to write on something, but the document that they print out could contain sensitive or confidential information. So another thing to alert employees and to make sure that they think about this, if they have printers at home, to make sure that they don't just print anything without thinking carefully about what they're printing and where they should be printing it, apart from just the environmental concerns, of course. So if possible, I think people shouldn't be printing if they could store information online. But if they have to print, they need to be reminded that paper could contain personal or confidential information, and that they need to manage that carefully. Okay, so as I've already mentioned, people need to remain vigilant. They need to be informed of the security risks. So it's a good idea to keep on reminding people about that, what they do with their devices, where their devices are stored, who has access to those devices, making sure that they update their software, that they use proper antivirus software. So the whole idea is to foster confidentiality awareness even in these times, so that people can remember that the information that they have is still private and confidential. The fact that we're in a pandemic doesn't mean that they cannot do anything with information. So let's say people share a house. They might be used to leaving their computer open in their office, information and paper on their table. If they now share a house with two other people, the good thing to do would be to make sure that they lock their computer, that they press Control-Alt-Delete and lock the screen. If they're not at their computer, of course, they probably trust their housemates, but you have to be careful. There's no reason why someone should have access to information that is confidential. So it's important to remind people about these things, especially if they're sharing their living space with someone else. Another thing to look at is the service providers that you use, to make sure they are reputable, that the services that they provide are in line with good corporate governance and good privacy principles. So if you use new service providers in these times, to focus on the privacy aspect as well. And then if there is a data breach, you need to decide how you're going to handle that. Many organizations have data breach policies, and there's a lot of information on the internet that you can find about this. And this is linked to disaster management. So if someone doesn't look after the IT systems at the office because everyone is in lockup and there's a failure caused by a power surge or the aircon not working in the service room, how are you going to handle that disaster? You'll have to think about that now already and prepare yourself. And work on POPI already at the moment. You can start working on the training, as I've mentioned, but also the privacy notices and privacy policies that you will need. If you have these notices, it's a good time to update them now, because things will change. The information that you gather changes, the nature of that information changes, the way in which you process the personal information would have changed, and also your purposes for which you are gathering that information. See whether you have an IT and email usage policy, for example, in place. These days, most people are working from home. What can they do with the internet that you might provide to them, or the email access, or the online storage? What can they save? Look at your policy. Do you have a policy? If you have a policy, check whether it needs to be updated. And then just lastly, because I'm conscious of time now, when it comes to social media, there are also some risks that people have to think about. Obviously, to make sure that they don't distribute fake news. The disaster management regulations, of course, talk about this as well. But even in a business context, if you have a WhatsApp group for your employees, you could have started that group, for example, because you don't have daily interaction with people inside the office. Make sure that they don't spread fake news on that WhatsApp group. If you're the admin for that WhatsApp group, if you're aware that fake news is being spread and you're not doing something about it, so for example, you're not removing that person from the group or deleting the posts, you could be held liable. There's been more than one court case where it's been found that someone who hosts a social media profile is responsible for what's happening on that profile, especially if they find out that there's illegal or unlawful information that is being posted. There's been a case, for example, where an organization had a Facebook page and people were posting defamatory and unlawful comments on that page. And the court said that they had a duty to remove those from the page. And also make sure that, because people use a lot of social media at the moment, they might not be that busy, that they still remain conscious of the sensitivity of business information. So, for example, if they're sitting in their home office and they're tweeting a picture of their home office, if there are confidential files lying on the desk, that information could cause harm or cause embarrassment if it comes out. So remind your employees to respect privacy even in these difficult situations that we are facing. Also make sure that you know who is using your social media account at the moment. You might be using someone in marketing who's posting on your behalf. Make sure that you have access if something goes wrong. Let's say in the unfortunate situation where they become ill, where they test positive and they end up in hospital, do you have the password so that someone can keep on posting comments or posting updates on your company's social media accounts? And then obviously be aware of the security risks as well. There's been a lot of examples the last few days of how hackers and cyber criminals manage to get a lot of personal information through, for example, online games or one of these online questionnaires. There'll be a questionnaire, for example, that will say, what was your first pet's name? What is your mum's maiden name? And then people fill it in and they reshare it again, not thinking, because those are normally the questions that people have to answer if they've forgotten or lost their password. So people don't think, they post this information and carry on with their lives, and next thing someone manages to hack into one of their accounts, and it's probably a situation where they posted quite sensitive information without thinking about what they were doing. Just lastly, when it comes to privacy, we've heard, and this has now been published in the disaster management regulations, that government will be able to track people's whereabouts, but this must obviously be done in order to try and manage the coronavirus outbreak. So if someone has tested positive, apparently they'll be allowed to, and the cell phone networks have agreed to this, they'll be able to find those persons and see who they might have interacted, so they can warn those people to self-isolate or to get themselves tested as well. One of the retired Constitutional Court judges has been appointed to oversee the process. The risk, of course, here is that information is all being stored centrally by government. We'll all hope that the information is safe and that it can't end up in the wrong hands. There's also a duty on government, if they have accessed your location after 6 weeks, at some stage, they'll have to let you know that they've accessed your whereabouts. Most countries across the world are looking at similar kinds of means, and as I've said, even though the Constitution protects certain human rights, those rights have to be balanced against other rights. In this case, of course, the argument is that people's health and their lives are important, so therefore people can't expect their location to be absolutely private if knowing where their whereabouts could perhaps save a life or prevent someone from getting infected by the virus. Thank you very much. That's hopefully what I wanted to cover in a nutshell. I think we've had some questions.
Yes, thank you very much, Dani, especially for your informative and detailed analysis. I think it's particularly when it comes to legal things, it's quite difficult. I see we've got a lot of marketing managers here today attending, and from different departments as well. It's always good to get an overview. And if you allow, well, we will share your contact, well, not share your contact information, but we can definitely, if anyone has further questions, they can get in touch with us, and I'm sure we'll be able to put you directly in contact with the experts at Adams & Adams who can go through in more detail if you have specific questions. We do have quite a few questions, so I'm going to jump straight into it because I'm also cognizant of time. So are you ready, Dani, for all the good questions you've got? All right, so we're going to start off with Emma, and she asks, POPI does provide some leeway with regards to disclosure of personal information of individuals who are suspected of fraud or corruption and are subject of investigations. It feels that this provision could be used as a loophole. How strict is POPI in this regard? Can this be used by law enforcement agencies or also by corporate investigative firms?
Yes, that's an interesting point. So the authorities can process personal information. Of course, there are checks and balances, and we'll hope that those checks and balances will be used. So if I say checks and balances, I'm saying here that the authorities shouldn't have carte blanche to access people's personal information to investigate a crime. In other words, there needs to be a reasonable suspicion. Anyone and everyone can't investigate crimes. Of course, this is the authority, the police and the law enforcement authorities. It's their job to do this. So yes, POPI will allow personal information to be processed for investigating crimes and corruption, and I think it is important. Of course, it would be a problem if we know that there's a criminal out there and they're trying to rely on their privacy. And in the EU, and the EU's law is very similar to POPI. It's stronger. The current GDPR is stronger than POPI. But even in the EU, there's been situations where criminals have tried to rely on those rights and said that, well, this information is private, you can't process it. And they've lost in those scenarios. But of course, when the authorities process this personal information, they'll have to take steps to make sure they still comply with the law. So they can't go on a fishing expedition. They need to know what information they're looking for. they need to access that information, or only the information that relates to the crime that they are investigating. Obviously, making sure that the information still remains confidential. They can't now go and publish it or put the docket on the internet. So yes, it could be abused, but even in the current scenario, the police can investigate crimes. When it comes to private investigators, it's going to be a much more interesting question. I think they might struggle. There are certain grounds that I think that you might be able to use, but you can't use the law enforcement grounds. A private investigator, for example, or a forensic auditor is not a member of the police force, for example. So they'll have to find other grounds on which they can do so. And I think you could, for example, say that it's in your legitimate business interests, for example, to investigate fraud that is happening in your organization. So sometimes you might still be able to do so, but I think the burden will be heavier in those situations.
Perfect. Just to lead up from that, because I see we have a lot of international companies here today, of course, particularly some French companies. Is it safe to assume that if we're operating between the two, say, for example, a French company in South Africa, we would need to be compliant with both the POPI Act when it comes into force, as well as the GDPR?
Yes, it's actually a tricky situation. So the GDPR applies if you process personal information of EU residents, so not necessarily EU citizens, but people who reside on a normal basis in Europe. If you process their personal information, for example, if you track their location, for example, or if you do direct marketing to them, then even though you might not be in the EU, you have to comply with the GDPR, which is the EU data protection law. If you have a multinational that has a head office, for example, in France and a company in South Africa, well, yes, then the head office will have to comply with the GDPR. The local office might also have to comply. Let's say in the odd situation that your HR section sits in South Africa and not in Paris, for example. If they are processing data that relates to EU residents, then that section will have to comply with the GDPR as well. Obviously, the local office of the French company, the local office in South Africa, it will have to comply with POPI. Fortunately, and I've seen this with a number of my clients that are multinationals, those that are already in Europe are much more privacy conscious. They obviously had to rush around to try and get their organizations to comply with the GDPR. So if you're already compliant with the GDPR, you're in a position because your organizational culture will already have been adapted to complying with strict data protection laws. However, there are certain differences. So although the GDPR is stricter than POPI, and POPI is based on similar provisions, so I can basically just, let's call the GDPR POPI version 3 or POPI on steroids. There are actually some differences, and people don't always realize this. So the GDPR only protects people's personal information, so human personal information. POPI, for some odd reason, and this is really an exception, there's only a couple of countries that is the same. POPI also protects corporate personal information. So certain information relates to a company and not to a person. That information is regarded as personal information under POPI. So if you are a company in South Africa and you process personal information of corporates, you'll have to make sure that you have your processes in line, because many European organizations are not used to this, because in Europe, corporate information is not subject to the GDPR. And where your risk also lies is that POPI says that if you want to transfer information across South Africa's borders, you can only do so under certain situations, in certain instances. So for example, if you're transferring information to another country and that other country has a law that is the same or better as POPI. Now, when it comes to corporate personal information, if you're taking corporate personal information, let's say your customer corporate database, and you want to transfer that to Paris, you can't just say, well, I can do so because Paris is in the European Union and they have the GDPR there, because the GDPR does not protect corporate personal information. You can still do so, but then you'll have to put in place what they call binding corporate rules. So what you'll do is you put a policy in place saying, as a group, our multinational company, we agree to the following principles. So for example, if we transfer personal information cross-border, we'll comply with the strict requirements of POPI, or you'll put a data transfer agreement in place. So if you're not in a group setup, if you're a company in South Africa, you often do business with a separate independent French company, and you need to transfer some corporate personal information to that company. You can do so, but then that company in France, because they'll be receiving the information and the information won't be covered on the same basis there, you'll have to make sure that by agreement, they basically agree to comply with POPI voluntarily.
Okay, perfect. Thank you. Now we have another question from Anonymous, and they ask, how does POPI apply to the security officers at complexes/estates? They scan your driver's license and car disc for you to obtain access, but where is the information stored and how safe is it? No guard/security provider has ever been able to answer this question. For what reason do they require this info, and what repercussions could there be if any is attacked, if anyone is attacked or hijacked, touch wood, that doesn't happen, whilst waiting for these validations to take place? I think it's an interesting question, actually.
Something that I'm also really worried about. Every time that I drive into a complex or an estate or an office park, I sort of get shivers when I hand over my driver's license, because people don't realize that when they scan that driver's license, those scanners and the software, they normally link up to the Inatus database that contains really sensitive information. I mean, it's the information that you fill in when you go and renew your car's license disc. And a lot of people just hand over their driver's licenses, and I'm really worried about that. Even at the moment, of course, we don't have POPI, so it's difficult to say that the security companies at office parks or complexes or whatever, that they're breaching a law. Under POPI in future, I think they'll really have to reconsider their situation. So of course, yes, it's in the legitimate interests of the people living in that estate to remain safe, and therefore they might need to know who is coming into their office park or into the housing estate. But you have to make sure that you have proper mechanisms in place and that the information that you collect is necessary. How far you go in collecting the information, what kind of information you collect. I'm really worried about the information that people can access if driver's licenses are scanned. I'm not sure if one can say that all that information is really required. And then if, yes, of course, you can maybe fill in a book and say that so-and-so is visiting and this is their cell phone number. But what happens to that book? Who can have access to that book? Do you vet and screen the people that work at the security company? What happens if there is an information breach? If that book gets lost or stolen, or if it's stored on a computer? And really, I've seen all sorts of, just like we all do, probably some security companies and some complexes are stricter than others, and some operations are not necessarily up to scratch. What happens if that information gets lost or stolen? How do you contact all those people saying, everyone now has access to your cell phone number because the book has been stolen or our computers have been stolen? So you'll have to make sure that you put proper processes in place. I think in future, when POPI is in place, one will have to be, all these security companies and body corporates will have to revisit their processes and put proper mechanisms in place that they limit the kind of information that's requested, what they use it for, and obviously where and how it's stored and for how long. You can't keep that information for forever. It needs to be deleted at some stage. Same with CCTV footage.
And also in that, say for example, you scan your driver's license going into an office park, and essentially I think from your concepts, there could be that security service could be acting as the operator. If there is a security breach, who would be liable? Would it be the company who is now employed that third party, or would the liability lie with the third party?
That's an interesting one. So under POPI, as I've said, POPI will allow civil liability. So even though the regulator will enforce POPI, if someone breaches POPI, you can go to a normal court as a data subject and sue that body if you've suffered damages. Where the liability lies is an interesting point, and it's interesting that you mentioned that, because in the last week or two, there was a case in the UK that dealt with this. In legal terms, we talk here about vicarious liabilities. In other words, if I have an employee and they do something wrong, am I liable for what the employee has done or not? And as I said, POPI is very similar to the GDPR. It was based on the GDPR's predecessor, the EU directive. So our regulator, I think, will follow will closely what the courts in Europe do, even though the UK is now has left the EU. The EU, well, the UK Data Protection Act is sort of in line with the EU directive. So we can still look at what's happening in the UK. And what happened in that case is an employee, obviously upset about something, took personal information and leaked it on purpose. And someone tried to sue the employer, saying, you had an employee that leaked the information, so I'm holding you liable for the damages and not the employee. And it's interesting there, the court didn't hold the employer liable, saying an employer is only vicariously liable, and it's the same principle in South Africa, if someone does something in the course and scope of their employment. So if I'm using a garden service, just as a silly example, and they chop off the wrong tree, of course, and that's a very expensive tree, I can sue the garden service because the employee cut off the tree in the course and scope of their employment. But if that employee then, this is our law, if that employee then steals something from your house, you can't hold the garden service liable because the employee was not acting in the course and scope of their employment. So on that basis, and it's these principles that the court in the UK has applied, they've said that the employer can't be liable there because the employee acted outside the course and scope of their employment. And I think that judgment will probably be used if this situation ever comes up in South Africa as well. What is different here, though, is so employees can be held liable. You can hold the employer liable on this vicarious liability basis, but it could also happen with a contractor. So if you have a security company who is your contractor, I think on that same basis, you might be able to hold liable the responsible party, so the body corporate or the office complex or whatever, because they've used a security contractor and they have processed the personal information in the course and scope of that contract.
Yeah.
Again, if you then have a rogue security guard there who then takes that book with all the personal information and goes and copies it, or takes a disk and puts it on the internet, if a South African court looks at that UK judgment, then they might say, well, in that case, the responsible party can't be held liable. But you might still be held liable on other bases. So, for example, if your processes are still not up to scratch, so the reason why the employee got access to the information is because you didn't have proper security controls in place in the first place, might be a basis on which you can be held liable nonetheless. So, one will have to see in the context, but I really think this is going to be a hornet's nest that will be opened up as soon as POPI comes into force. I think the information regulator will be inundated and will be flooded with complaints, especially when it comes to access to buildings and to office parks. I don't know how they're going to cope with all the complaints.
All right, perfect. Now we're just going to move to a question from Paul, and I think this relates to a little bit about what we just spoke about, but maybe expands a bit. And he asks, is there a minimum requirement or criteria specifically mentioned in the POPI Act that must be met regards to the safekeeping of personal information, both physical, hard copy, and electronically? For example, if there is a breach and personal or confidential information is leaked, who determines whether the information was appropriately stored in the first place? And I think you also mentioned you need to have reputable service providers. I mean, how do you sort of judge that, and how do you determine whether that information was stored correctly in the first place? Who is the judge?
So POPI doesn't actually contain a long list of requirements or sort of a standard against which you can measure information security. What it basically says that you have to take reasonable and appropriate technical measures to make sure that you keep information secure and free from unauthorized access. So it basically sets the principle there. And then what those reasonable technical measures are, you have to compare to what the industry standard is, basically. So what we normally say there is what would a reasonable business do in that case? And this has crystallized. So, for example, in the IT sphere, there's an ISO standard on information security. It's quite a complicated, and it's a difficult standard to meet, but there is an ISO standard. There's more than one, actually. In Canada, for example, they've brought out certain privacy principles that people can apply. In the US, there's sort of there's an IT standard that sort of is not that difficult to comply with, actually, but in the US there's an information security standard that people comply with. So there are all sorts of international benchmarks that you can use when it comes to IT. So, for example, do you or should you not use two-factor authentication? In other words, should someone type in the password and get a PIN that is on their cell phone number? How must your antivirus software function? How do you manage access to certain files on a server? So there are international standards, and if you ask any information manager or CIO or IT manager who's worth his or her salt, they'll be able to tell you what is best practice. And so if there is an information breach when it comes to electronic information, the regulator will hold you against that standard. If it ends up in court, if you want to sue someone, a court will probably, the claimant will probably get an expert in IT security, and they will say, well, any good business would do the following. They'll have antivirus software. They'll make sure that people have passwords. And because there wasn't a password on that laptop, someone suffered harm, and therefore, yes, you are liable because you're negligent. So that's how it will work. And the same will apply to hard copy information. So POPI doesn't say you must put books in a cabinet and it must be fireproof and you must lock it up. It doesn't say that. But that is best practice. So if you have certain very sensitive files, you have to store them under lock and key, because if someone breaks into the office, they could get access to that information. So I think here the answer is probably one must look at what is best practice, and one can determine that one way or the other.
All right, perfect. So we're going to move on to a question from Adrian, and he asks, if a responsible party or operator obtains data that was initially obtained in an unlawful manner, but they have no knowledge of the defect in lawfulness, how would this affect their liability, and what would their obligations be towards this data and the persons it relates back to?
That's a good question. Thanks, Adrian. My view would be here is if the information is tainted, it is tainted, whether you knew about it or not. We're talking about a law that is very specific. We're not necessarily talking here about intent or negligence and those kinds of things that we deal with in the current situation. And I think, to use a practical example, if I use a marketing company and I want to send out email newsletters and they hand me an Excel spreadsheet containing people's email addresses, I can't just assume that I am allowed, when POPI has come into force, to send direct marketing emails to those people because I'm not aware of any problem with that information. I don't know that information has been sourced from the dark net because there was an information breach. I don't know whether the person who gives me that spreadsheet, whether they've obtained consent from those people to receive direct marketing material. The point is, I am now processing this personal information. And if you look at those principles that I've talked about earlier, accountability, lawfulness, I can't just assume that what I'm doing is legal. I can't assume that I am processing information in a lawful manner. I will have to take steps to make sure that I am complying. And when it comes to POPI, I'll have to make sure, while I have this information, before I even ask whether I'm allowed to have this information or process the information, the question is would processing of this information be legal? So I think it's going to be tricky in future, especially in those situations where you have information for whatever reason, and you want to keep on using it. So, for example, if you have a direct marketing database and you want to keep on using that database in future, it might be a good idea to maybe start from scratch and building up as a clean database if you really want to be careful that you don't breach the law.
Okay, perfect. And also cognizant of time, I'm enjoying all these questions, so I'm just going to go for the last two questions. So we have one from Melanie from the French Chamber. Thanks, Mel. And she asks, with all businesses being forced to go digital, they are raising concerns about data protection with regards to the online platforms used for meetings and webinars, such as we are today. Does the current legislation in South Africa, POPI not being enforced yet, cover this use and protect the contents of these meetings and or webinars?
No, so we don't really have proper legislation that regulates that at the moment. RICA does to a certain extent. So, and the Electronic Communications and Transactions Act. So if someone hacks into something, that is still a cybercrime. It's a very basic crime at the moment. That act dates back from 2002, believe it or not. There's a cybercrime bill out there. But if someone hacks into one of these services and you can prove that, you know, then you can open a case against them for doing so. When it comes to using these services and the standards that they have to meet, there's nothing basically. So without POPI, we can't say these services have to comply with a certain standard in South Africa. So that's why I think businesses have to look at what is good business practice. If, for example, you know that a certain service is not trustworthy, if you know that it's not secure, if there's been reported cases or something in the press about a service being hacked on a constant basis, well, then you could end up in problems if you use that service for a sensitive business meeting, for example. And if you're worried about that information getting into the public domain, then I would tread carefully and do some research, even on the internet. And there are some services that I know of, because I've read about them, that are less safe than others. Some of them we all accept because we know that we're using them for free, so we're not going to complain. But you know, if you want to have a very super sensitive board meeting, then I would rather go for one of the paid services or a service that forms part of your current software package that you're paying for. Because normally, unfortunately, what you pay for is what you get. So be careful what you're doing. It's interesting. We're seeing these photos of our cabinet holding some of these meetings, and I recognize some of the software in those photos. So I'll reserve my comments about this, that they sometimes use. Others,
All right, so I think the moral of that story is do a bit of research. All right, so we're going to end off finally with a question from Barbara, and she asks, with regard to the POPI regulations in regard to COVID-19, shouldn't the employer be able to disclose the identity of an infected employee to all the company other employees in order to identify other employees that may be in contact with that person?
It's a difficult question, and I don't want to give legal advice here, but I think the basic principle should be, as far as possible, maintain confidentiality. So unless you have to disclose who that person is, don't do that. If you want to do that, I would say that you have to look at that scenario carefully, maybe to contact the Department of Health or whoever is in charge here, the NICD, and make sure that it will be fine to disclose that personal information. The disaster management regulations do also protect people's confidential information. The National Health Act protects health status information. So you need a very good reason to give out that situation. So, and in some instances, if you know 5 people work in an office and you know one of them has tested positive, it will probably be fine to just tell those 5 people someone in that office was positive. But I guess there will be some situations where it is really important to make sure that you tell someone it's so and so. But I think often you'll be able to do that without actually disclosing that specific person's name. If you want to do that, I would get proper advice and looking at the specific context to figure out, is there a way to not do it? Because if you're doing it, if you disclose that information and you could have dealt with the risk, in other words, avoiding other people getting infected or making sure that they go and get themselves tested, if you could do it without disclosing that person's identity and you then still disclose the identity, you are going to face problems one way or the other. And I think it is important to do so because we don't want a situation where people are worried about the confidentiality of their health status, where they don't want to go and get themselves tested because they're worried that it will come out and it will end up in the company newsletter. We want people to get tested so that we can, government as a society, we can get this situation under control. But on the other hand, we don't want to let people feel too shy to come forward because they know that there's this risk that they might be named and shamed, so to speak.
Yeah, and I think particularly in South Africa with a lot of stigmatization, if we look at things such as TB, HIV, all those kind of things, I think that's probably a good principle to abide by. All right, and on that note, I think we're going to conclude the Q&A session. If anyone has any further questions to ask following this, please do get in touch with myself or anyone from the FSACCI team, and we'll be able to put you in contact with Dani or anyone from Adams & Adams, and I'm sure they'd be more than happy to share their expertise with you or your company. So please do get in touch. If possible, Dani, are we able to share the PowerPoint presentation?
Yes, I can send the slides. I'll send you.
All right, fantastic. So we'll send everyone here today the copy of the slides, just to give you a nice recap in case you've run out of books to read during the lockdown period and you want some light reading. I'm sure that would be a good use of your time. So I'd just like to extend a big thank you to you, Dani, as well as to Adams & Adams for lending your expertise here today and providing your expertise on such, I think, an important and going to be increasingly important topic, not just for individuals, but for companies. And I'd just like to thank all those who attended today. Thank you very much for logging on and joining our webinar series. Just a reminder that we are doing another webinar tomorrow, a special one given the lights of the immigration status, particularly for a lot of our expat community, and the new regulations that have been announced this week. So if you would like to join that one, please do. You can find the information on our website. And furthermore, you can please consult our Q&A page on the website if you have any business-related questions surrounding COVID-19. We have a team of specialists who are able to provide you some general information, and if you need any specific information, we'll try our best to put you in touch with the relevant people to answer those questions. So on that note, I wish everyone a wonderful day. See those tomorrow who are interested in immigration, and thank you very much, Dani. Enjoy the rest of your day and stay safe.